Good evening, everybody. My name is Bérénice Boutin. I'm a researcher at the Astor Institute, and I wish to welcome you all, everybody, to this Supranational Criminal Law Lecture. This event is part of the Supranational Criminal Law Lecture series, which have been running since 2003. And this lecture are organized by the Astor Institute in cooperation with the Coalition for the ICC and with the Grotius Center for International Legal Studies of the Leiden University. Tonight we are very happy to welcome Professor Olasolo. Professor Olasolo holds a chair in international law at Rosario University in Colombia. He's also the chairman of the Ibero-American Institute of The Hague for Peace, Human Rights and International Justice, and ad hoc professor at the Hague University of Applied Sciences. Professor Olasolo, thank you so much for being with us. I give you the floor.
Well, thank you very much, Berenice. And thank you, everybody, for coming here today. I see many faces that I know and many old friends, so it's great to have an opportunity to meet and hear when I come to The Hague. And it's always great to come back here to the Astor Institute. We try to organize an annual lecture on issues concerning Latin America, and in particular Colombia, here at the Astor Institute. So it's always great to be here. I also want to thank to the Grotius Center and the Coalition, which are also co-organizers of this lecture. The talk that I'm gonna give is gonna be basically I'm gonna make some points and I'm gonna pose some questions. It's more like a reflection. We'll probably have it in the website, and the slides will also be available. So everybody who wants to access all content, you can access it through the website. I'm gonna stand up, and then we can go ahead with the presentation. Do you hear me? Okay. Now, we have given several lectures about Colombia, so I didn't want to just go back to the whole story of the country, and particularly the transitional mechanisms that they have put in place. In last year, we have like almost an hour and a half. Christoph just remind me about that, so it has to be shorter this year, in which we started from 2003 and we went all the way through until the legal framework for peace. So I'm going to just go very quickly through those mechanisms because we need to understand a little bit about them, and then we are going to focus really on the proposed. And I say proposed or established, but we don't know yet what is the exact content of the agreement. We have a press release and we have some details, but everything that I say here is provisional. So let's put it that way, okay? Which is a special jurisdiction for peace, which is part of a new comprehensive mechanism of transition. You realize that I don't talk about transitional justice. I talk about transition and transitional processes, because I believe that this is a political mechanism. So we are in a political negotiation, and as a result of a political negotiation, we are going to know how we deal with the past. And the mechanisms that we put in place concerning truth, reparation, justice, guarantees of non-repetition, and also those measures that are going to address the social, political, and economic issues that were the objective causes of the conflict, they are all part of a political negotiation. So therefore, to call it justice, when indeed what we are doing is basically to decrease the content of victims' rights, and at the same time we are also decreasing the content of states' duties. I'm very hesitant to use that word. So that's the reason I prefer to call transitional processes. Now, in Colombia we have several. So let's start. Well, the first slide is about the groups involved, but I believe that you are familiar with that. I mean, the guerrilla group involves, the paramilitary groups, some of them demobilized, others partially transformed into bandas criminales, BACRIM, and then we have also the governmental forces involved, the military, the police, the intelligence, and the areas of the civil administration at the local, regional, and national level. So this is nothing new. It's a conflict that has lasted for 50 years, 60 years. Some people put it in 1936, where they had that march in which the interest of the vast majority of Colombians were put on the table, on the political agenda in the country, and because they were not satisfied, some people say that was the beginning of the violence. Others put it in the 60s. Others even, they say it changed in the 80s and 90s, and it becomes more like narco-terrorism. So there are many explanations to this. Now, the fact of the matter is that this is a conflict that has lasted for several decades. Now, concerning the victims, we have many of them. In fact, probably 1 out of 7 Colombians and 1 out of 8 Colombians have been victimized. So it's not just a few of them, there are millions, and it's a good percentage of the country. Probably 15%, 12-15% of the country has been victimized. And this is important to keep in mind, because when we talk about reparations, we talk about reparations for 12 to 15% of the country, if those are the victims of the conflict. So we are not talking about reparation concerning a few hundreds or a few thousands. We are talking about reparation concerning a very important percentage of the country. We had different crimes, individuals that were killed for enforced disappearances, forcible displacement, victims of sexual assault, that the ICC continues or keeps saying that still they are not being investigated, or they should continue investigating because they have been kind of left aside. The same with extrajudicial killings, another area of focus of the ICC in the last years, kidnapping of civilians, recruitments of minors, etc. Now, the 2 next slides are about transitional mechanisms. And the same, whereas Colombia is one of the most diverse countries in terms of vegetation and in terms of animals and species, the same Colombia is a very diverse country in terms of transitional mechanisms that have been put in place. We have had judicial mechanisms, we have extrajudicial mechanisms, we have now a new mechanism which is a mixture of both of them, but it's clear that we can look at the peace and justice law on the one hand and the legal framework for peace as 2 different separate transitional mechanisms. The first one is based on a judicial proceedings for the most part, the second one is based on administrative action. So you have 2 different types of transitional mechanisms, and all of them, both of them, they deal with truth, justice, reparation, and guarantees of non-repetition. It's just 2 different ways of dealing with it. Now, if we go to the first one, very quickly, we'll see that this is limited, or was limited in 2005, to members of the paramilitary groups and guerrilla members. And this is important. Guerrilla members were included in this model. Members of the FARC have demobilized following this model. So this model is applicable to members of FARC. And therefore a question will come up later. So why should we have now a new mechanism for members of FARC if we already have one in place 10 years ago? And we have around 600 individuals, former members of FARC, that demobilized through the peace and justice law. So that's the first question that comes up. Now, in terms of truth, we'll see that truth in this model was very much based on judicial proceedings. We also have a commission for reconciliation and reparation. And basically, the commission issued a report, but the reports issued by the commission were, for the most part, very focused on certain areas. So, if you look at the broader picture, that broader picture came through judicial proceedings. So for those who say that judicial proceedings will not get us to the truth, this is an example that this is not really accurate. Indeed, if you read the 35 judgments that have been issued in Colombia concerning each region, because we have more or less 1 or 2 judgments per region, you realize how the country worked, who realized where the paramilitary groups operated, who realized who was or which were the state authorities that were involved with the paramilitary groups, the private actors that were supporting the paramilitary groups. You also know who was fighting against the paramilitary groups or who was opposing the paramilitary groups, and also who was supporting those opposing the paramilitary groups. So if you look at the judgments of the peace and justice chambers, basically you have a pretty good idea about what is true about. The problem is that nobody has read it. I don't know any one person outside Colombia who has read the 35 judgments. Nobody reads them. Everyone talks about them. He says they're useless. But no one has really taken the time to read them. So maybe we should take the time to read them. And see if we read them all, and we read the 10,000 pages that they have produced, what is in there. Because basically we may be very surprised about what we find. Now, in terms of justice, Colombia is one of the 3 countries of the world which applies international criminal law on a systematic basis. Argentina, Colombia, and Bosnia are the only 3 countries in which you really apply international criminal law, and indeed, you find a job as an international law practitioner. If you study international criminal law, you're not going to find a job at the national level except in any of these 3 countries. That's the reason many of us who practice international criminal law have ended up in these countries. It's true that there are national proceedings in other places. That's true. But they are isolated. They are kind of symbolic. But when you look at the large scale number of cases, Colombia is one of them. Now, Argentina did proprio motu. When the Kirchner came to power, they did it proprio motu. And now that the government has changed, we have to see whether the trials will go ahead or not. That remains to be seen. Now, in Bosnia, it was the result of the work of the ICTY. Basically, the work of the ICTY and the completion strategy to a great extent made the national authorities in Bosnia to start a large number of prosecutions. Right now they have around 2,000 to 3,000 prosecutions pending right now, as far as I know. So, and the third case is the case of Colombia. The case of Colombia is a combination of factors. The most important ones, I will say, or 2 of the most important ones, can be, say, the combined action of the Inter-American Court of Human Rights and the International Criminal Court. So the combined action of both probably press national authorities in Colombia to do something they haven't done before, which is fight against impunity. Because if you look at the cases in the 80s and you look at the cases in the 90s, there were very little judicial activity. And however, it started at the beginning of the century, and for the last 15 years, or 10 years at least, we have a good number of cases and a good number of convictions. We'll see afterwards. So, these are the 3, as I say, states or countries in which we apply international criminal law. Now, in the case of Colombia, we not only have proceedings at the Peace and Justice chambers, but we also have proceedings at the Supreme Court. And this is a very interesting case because it's the only one I know in which those in power end up being prosecuted and convicted. All those congressmen, members of Senate, governors that were linked to paramilitary groups, they were members of the party that supported former president at the time he was still in power. So they were not prosecuting the opposition. They were not prosecuting the defeated ones. They were prosecuting precisely those that were supporters in Congress of the president. That's something very unusual. I will say I haven't found any other case in which this happens. Very, very unusual. And it's not just a few of them. We have around 60 convictions. So 60 members of Congress and 60 members of the Senate were prosecuted and convicted. Now we also have 15 state governors. And I know if you go to some regions, basically there is a conviction of one governor after another. In some regions you have 4 in a row. But still, there were some prosecutions at the regional level. I wouldn't say at the national level in terms of members of government, but I would say at the regional level. Now, we also have ordinary jurisdiction, and the ordinary jurisdiction open cases against hundreds of military officers and police officers and intelligence agents, and even the intelligence department was closed down. In 2005, the DAS, which was the intelligence department, the civil intelligence in Colombia, was closed down. And it was closed down because it was involved in illicit activities, and the government decided to close it down. So, that was dealt with by the ordinary jurisdiction. And indeed, if you look at the proceedings right now, they still have 9,000 pending requests for investigation concerning national authorities, concerning military, intelligence, police staff, concerning staff that work at different ministries, concerning private actors. There are 9,000 pending requests. Really, I don't see any other country in which this is being done. No. No. If you look at the amount of proceedings, and if you look at the people against those requests are being made, and also the convictions are being passed. Now, there is still a lot to do, or in the sense that they are still in their way, but a lot has been done, according or through this judicial mechanism of transitional justice. Now, we also have, as I said, we had the military jurisdiction. That doesn't work that well, let's be clear, and it was interesting because they just extended the competence, which is not good. They extended the competence of military courts. They extended the jurisdiction. So, if you have military courts that do not work, and you extend the jurisdiction, that is not really a guarantee of non-repetition. That was the other way around. And it was interesting because in the whole debate on whether or not military courts should have a broader jurisdiction, nobody really debated on the effectiveness. Nobody really looked at the cases that they have dealt with in the last 10, 15 years. Nobody looked at whether those that are working in those jurisdictions are independent or not. That wasn't relevant, and that is striking. Now, in terms of reparations, here there was something very interesting. And the reparation, because the reparations procedure, in principle, was going to be judicial. So it was going to be the peace and justice chambers, the ones that were going to determine the reparation measures, the amount of compensation, the measures for rehabilitation, for satisfaction, etc. However, as soon as they started doing so, the government got involved and they passed a new law in which they established an alternative reparation system. That was an administrative one, in which you have fixed amounts, which were, of course, very limited in comparison to the amounts that were being granted by the judicial chambers. And this alternative system worked in the following way. You basically, if you want to have your reparation up front, you go to the administrative system. If you don't want to have your reparation up front, and you hope that you make it a better reparation by waiting 2, 3, or 4 years, then you wait until you have a judicial ruling. So you choose. Do you want to have up front the administrative reparation? Go for it. Otherwise, you can wait for the judicial proceedings. With the problem in the judicial proceedings that we didn't have money that was really committed to pay for those reparations. So the administrative reparation program has up to $400 million per year. But we didn't have money allocated for the judicial reparations. So after the first case, all money that had been given by those demobilized was over. And reparations, judicial reparations, could not be executed, basically. Now, as you can see, you have shadows, you have lights. It's a mixture of feelings, but you can see that at least for those that are more interested in truth and in justice, not injustice but justice, okay, this is a model that works out to an important extent. And the measure to see how it works out is like you tell me which country has made more investigations and prosecutions. You also tell me which country has explored the truth of each region of the country to the depth, or to the level in which the Colombian chambers have done so. In terms of reparations, it wasn't very good. It was complicated, it was complex. Victims did not get satisfaction for the most part, and in terms of victims' access to the judicial courts, there were mixed feelings. Let's move to the next one. This one is a hypothetical one because it is in the Constitution indeed. It is in Article 66 and 67 bis of the Colombian Constitution, but as far as I understand it will never be applied. That's how I understand it, because if we have a new agreement with the FARC in which we have a different model, this, at the end of the day, that was supposed to be the framework for the transitional process after getting an agreement with the FARC or with other armed groups will never be applied. So this is a hypothesis that went so far as to get into the constitution of the country. So it wasn't just a hypothesis. Now, this is, as you can say, an extrajudicial mechanism. Here there is no judicial involvement. I believe that Colombian authorities thought that they had too much of judicial involvement at one point. Because that was not negotiated with the FARC. This is not an agreement, it was negotiated with the FARC. The FARC always opposed it. The FARC always said, we were not part of the legal framework for peace, and we do not want to apply the legal framework for peace. So, this is the framework that came out of the government, and out of the discussions within the different branches. And this is an agreement, or this is a framework in which there is almost no judicial activity. You can see the truth comes through a Truth and Reconciliation Commission. There is no judicial involvement. The reparations are extrajudicial as well. You have a fixed amount of, well, now it's around $8,000. But last year was more. Last year was like $12,000 because the exchange rate has changed. So basically it's a fixed amount that each family gets. And that's it. And it gets it supposedly quickly because you get it up front. Now, it is forbidden. There will be no judicial truth in this model, and there will be no reparation grants issued by judges in this model. So the only involvement of the judicial branch is in justice, or concerning the justice element. And in relation to the justice element, the involvement is very, very limited. Because this framework gave the power to Congress to give an order to the General Attorney not to carry out any proceedings concerning genocide, crimes against humanity, and war crimes in relation to any perpetrator except for the most responsible ones. So you could only have proceedings concerning the most responsible ones. And you could have proceedings not in relation to any crime of genocide, crimes against humanity, or war crime, but just those that were systematic, that were representative of the way in which the armed groups or the state agents conducted their operations, and that had enough gravity. Finally, when you have a sentence, or when you have a conviction and a sentence imposed, originally the law that was passed said that it could be suspended. Now the Constitutional Court said that is unconstitutional, and therefore those sentences cannot be suspended. So they must be executed. But they can be executed through alternative sentences that can be served in special regimes. Like, for example, home detention, domiciliary detention. You can serve your sentence at home. So as you can see, this model is very different from the previous one. Absolutely different. And we don't have data about how it worked, or what are the results that it conducted, because it has never been implemented. We only have the reports of the ICC one year after another saying that they were very worried about this model, because this is a non-judicial model, this is an extrajudicial model. The role of the judicial branch is almost known. Doesn't have a role. Now, once we keep this in mind, let's move on. Let's move to the current negotiations. Now, remember, these two models were in place in 2012, and the current negotiations, they probably started before, but at least we know that they started in 2012. So these were the 5 points that they were looking at. And you can see that most of them have been agreed. The issue on land reform was agreed in May 2013. The issue of political participation of FARC was agreed in November. Then the issue of illegal drugs, which for Colombia is a key issue, that was agreed on May 2014. Then we have the issue of acknowledgement of liability and reparations to victims. And that is the one that we will be talking immediately after this slide. That was agreed in September 2015. And finally, we have the issue of disarmament, demobilization, and reintegration, and that is still to be agreed. Hopefully by March 2016, that's the deadline that both parties have given each other. By March 2016, they agree on this 5th point, and they will have a final agreement. Now, what can we learn about this agenda? The first thing that we can learn about this agenda is like truth, justice, reparations, and guarantees of no repetitions are not enough and will never be enough to address the social, political and economic problems of Colombia, those that gave rise to the violence. You may know what happened, but you are not going to solve the underlying political and social issues by knowing what happened. That's the starting point. You may fight against impunity, but we have also learned in Colombia that sometimes you get the conviction of a political representative, and in the next elections, the wife, the son, the daughter, or somebody who is a close relative gets the seat. So, fight against impunity is not enough by itself to change the way the country is organized, which is, at the end of the day, or was at the end of the day, one of the roots of the armed conflict. Now, reparations. Reparations, are they sufficient? Well, if we are talking about limited reparations, and if you talk about 8,000 euros or $8,000 for a family who has lost it all, or for a family who was in misery, I don't think that this is going to get them out, maybe from misery, but not from poverty. So, despite of the effort of the Colombian government, and when I say the effort, I know what I mean, because as far as I understand, this is the biggest reparation program that exists in the world, has existed in the world. If we don't take into account the US-Iran Claim Tribunal, and if we don't take into account the UN Reparation Commission for the Iraqi invasion of Kuwait, the biggest reparation program is the program put in place by the Colombian government, $400 million per year. And that's not enough. That's absolutely not enough. 15% of the country are victims, and the amount of money that we are giving them, 8,000 euros, doesn't get you even to buy a house. Of course, you don't get a mortgage, because nobody's going to finance you what is being left to pay the whole house. So you're not going to have a place to live. And that doesn't mean that you're going to have a dignified life afterwards. So yes, we are going to have reparations. Yes, we have the biggest program in the world after those two that I mentioned, but still victims will not have a dignified life. And this is interesting because for many years the model of South Africa has been shown as a great model. Well, in a country in which you have an apartheid policy for 70 years, and you have a large population, to say that the victims of the apartheid were 20,000 individuals, those that went to the Truth and Reconciliation Commission and testified there, and to provide 5,000 euros for those 20,000 individuals, I don't think that makes a difference. And we are seeing the consequences now. We are seeing the level of violence now. And we are seeing how the colored population in South Africa lives. 2/3 of the black population in South Africa is not in poverty, is in misery. They earn $1 per day or less. And this is our model? I think there's a number of reflections to be made about this. Okay? Now, so basically, what we have learned is that there are other issues that have to be addressed. And now, the Colombians, during this talk, some of them have been addressed. So, and we'll see if this is sufficient or not, because they are limited. So we have land reform being discussed, but we don't have any discussion on the economic model. We have no discussion on mining, for example, which is a key issue. Now, would that be enough to have land reform to get tens of thousands, hundreds of thousands of peasants in Colombia out of poverty? And I know it well because I have myself in a small piece of land, and I know who are my neighbors and how they live, and they are in poverty. So how do you get them out of poverty? Because when you have those people not making a living, and violence being a key way to make a living, or one of the options that are out there to make a living, no matter whether it is working for the guerrilla, working for the paramilitary groups, or being informants of the state, what are they going to do? What are they going to do? Now, of course, the second issue is the question of political reform, and that is another point that has been addressed. The FARC will have the right to organize a political group, a political party, and to participate in the elections. Now, this is part of the issue, but we are not addressing the issue that political seats are a merchandise, that we need to make an investment of X million of dollars or of euros, and then when we are in office we try to get a return, not only for us, but also for those who supported us. And this happens in Colombia, yes, but this happens in many other places in which we have violence. When political representation becomes a merchandise, then we have a problem. And finally, we also have the problem of illicit drugs. And the government has been very strict on this. It has changed. It has made a number of changes. Particularly, it has stopped aerial spraying, fumigations, which has been so bad for Colombians. So this is something very welcome. Now, who pushed the Colombian government to do so? The fight against drugs worldwide. And that wasn't the Colombians. And this is where we get to another issue, the involvement of foreign powers. And the level of involvement and responsibility that foreign powers have in the violence that takes place in a country. And my question for you is, how many Truth Commission reports do you know in which they talk of the involvement of foreign powers? Do you have any? Guatemala. Any other one? What? El Salvador. Okay, apart from those from Central America. Any other one? Because in Colombia also we have that already.
Maybe Afghanistan.
Maybe Afghanistan, maybe. Maybe not.
Maybe it's harder than Colombia.
So this is a key question. We shape our truth and our truth reports as if this was a matter just of the country, and it's not just a matter of the country. And when it comes to illicit drugs, for example, that is very clear. In fact, as far as I understood, last month or 2 months ago, the whole UNASUR, so the Union of South America, it went to the United Nations and it said, well, that's enough. Let's change the anti-drugs policy because this is not helping at all. It's harming us very much. And that was a joint action by all South America. Now, so we know from this agenda that truth, reparation, justice, and guarantees of no repetition will not bring us very far away in terms of the transitional process. We need more. Now let's focus on what we are more used to deal with, which is precisely truth, reparation, justice, and guarantees of no repetition. Now, the new jurisdiction for peace is supposed to be part of a comprehensive system, of a more comprehensive system, in which we will have a truth commission, in which we will have agreement for reparation, in which we will have a special jurisdiction comprised of chambers and a tribunal. And that jurisdiction, the members of that will be Colombians for the most part, and then there will be some involvement of foreigners. And we don't know how that involvement will be. We know it will be a minority, but we don't know if they will be judges or if they will be just observers. So this still needs to be clarified. Now the question is, what about international involvement being a minority? And the key question is, are we going to be in a tribunal like in Cambodia, for example, where we may have a minority of internationals, but they have a veto power? Will they have a veto power here if they are judges of the tribunal? And if they don't have a veto power, then would that mean that the Colombian judges may take a decision in one direction and the internationals take it in a different direction? There is a number of aspects to be clarified concerning this particular mix of composition between nationals and internationals. Now, what are the goals? And this is very interesting. The goals of the whole system, of the whole transitional process, start by saying meeting the rights of victims. Well, that is fully inaccurate. precisely a transitional process is a political negotiation in which you see what can be offered to victims according to the negotiating parties. But this will be far below of what their rights are according to international human rights law, international humanitarian law, and international criminal law. So in a transition, we always decrease the rights of victims. However, and it's not just the Colombian process, many of them have to portray as whether the key goal will be basically to satisfy the rights of victims. Well, we are doing exactly the other way around. We are decreasing them at the same time that we are decreasing the duties of the states. Until where can we decrease them? This is something up for discussion. If you wish, in the question and answer session. Now, the second goal is true. The second goal is to contribute to a stable and lasting peace. That is supposed to be the role of the Special Jurisdiction for Peace. So it's not about victims' rights. It's about contribution to a stable and lasting peace, which are two very different things. Now, what is important about this agreement is about the functions. Which functions will have this Special Jurisdiction for Peace? Because remember, we came from a judicial mechanism of transition, then we went to a non-judicial one, and then now we establish a Special Jurisdiction for Peace in which the functions are supposed to be ending impunity, finding truth, contributing to victims' reparations, prosecuting and sanctioning those responsible, not those most responsible, those responsible for international crimes, and ensuring non-repetition. So now it looks like that we are back to a judicial model. It looks like that we are creating a Special Jurisdiction for Peace, and we say that that jurisdiction can aim at all these goals. Is that possible? Let me just put you a question. Like, can a jurisdictional body make a contribution to ensuring non-repetition? Can make a contribution to lasting peace, which is the ultimate goal? These are questions that we have to think, because this is what they are agreeing, that this jurisdiction will make a contribution and its goal will be, for the most part, to further a stable and long-lasting peace. Now, there will be an amnesty law. And finally, we are getting to the point, because there have been so many discussions about this amnesty law, and so many misunderstandings, that even the Constitutional Court in Colombia got it wrong. Article 6.5 of Additional Protocol 2 talks about an amnesty law, yes. And it also says that the states will try, to the largest extent possible, to provide an amnesty to those that participate in an armed conflict. That's correct. As long as they don't commit genocide, crimes against humanity, and war crimes. And as long as they don't incur in serious breaches of international humanitarian law. That is in the commentary of the ICRC. That was the purpose of that provision, and that has been subject to all types of manipulations and misunderstandings. So let's have it clear. Yes, there will be an amnesty law, and the amnesty law will be within the scope of international humanitarian law. And according to what it says here, it will cover political crimes and crimes related to political crimes. So it will not cover genocide, crimes against humanity, and war crimes. And this is exactly the meaning that that provision had in Additional Protocol 2. Now, when you look at the crimes that will not be covered, one thing that calls your attention is that war crimes are not excluded as such. It's just serious war crimes. So we continue making these differences. We know that war crimes are serious violations of international humanitarian law. And now it looks like we have an additional distinction between just war crimes and those war crimes that are serious. So now we will have serious multiplied by 2 violations of international humanitarian law. Why? The question here is, why do we make these distinctions? They are not found any place in the law. Why? Now, the special jurisdiction for peace will cover the crimes we have been discussing. So we'll cover the crimes that are like the core international crimes. And now, there is one very positive element, which means that it will cover those that directly or indirectly have participated in the armed conflict. So this is not just for the FARC, this is not just for state agents, this is for everybody, for private actors, for those who have funded the different groups, for those that have assisted in different capacities to the crimes committed by these groups. So everybody will be within this jurisdiction. That is clear. That is absolutely different from the legal framework for peace. Remember, the legal framework for peace was just about the most responsible. This new framework is about everybody who has directly or indirectly participated in the armed conflict. So you say, the scope is very, very different. Now, the material jurisdiction, again, genocide, crimes against humanity and serious war crimes, but there is here a sentence which is also unclear to me. As long as they have been committed in the context of and for the reasons related to the armed conflict. So what about crimes against humanity, which are not linked to the armed conflict? What about genocide, which is not linked to the armed conflict? They are not in here. And we have cases that some of them are being tried and have been tried of crimes against humanity, or at least of factual situations amounting to crimes against humanity that might not be linked to the armed conflict. Now, we need clarification of what this means. We don't know yet. We need to have more information. Again, there is also a caveat in which it says that the special jurisdiction will exercise its jurisdiction in particular over the most serious and representative cases. But this in particular doesn't mean it will be limited to. It's like Article 8 of the Rome Statute, when it says in particular the ICC will exercise jurisdiction over war crimes when they have been committed pursuant to a policy. That doesn't prevent the ICC to try in cases in which you have isolated war crimes, and in fact it has done so. 2 types of procedure. There are 2 different procedures before this court, and this is something also that is unclear here. First, for those who say the truth and recognize their liability, what happened with them? I say what I did. I say what was my role within the group, and I also say whether I committed the crimes, or I pass over the orders, or I issue the orders, depending on which was my role in the group. Now, they come to a chamber, but what is this chamber about? And here is the key. Is this a judicial chamber? Or is some kind of truth commission? Because it's not clear to me from this wording. It's not clear to me whether we are more in a judicial setting as in the peace and justice law, or we are more in a non-judicial setting closer to the legal framework for peace. We don't know if these chambers will be judicial or will be comprised of members agreed upon by the parties, which are not part of the judiciary in Colombia. We have to know. Hopefully, they will be part of the judiciary, and hopefully the confessions will be done to the prosecution office, and once done to the prosecution office, they will be brought after having checked all the information that we have concerning other prosecutions, other sanctions imposed by other state bodies, other existing court decisions, and the information provided by NGOs and by human rights organizations. After the prosecution checks that, it brings it to the chamber. But it doesn't say so. It doesn't say if the prosecution office will have any involvement. And it doesn't say whether the chambers will be judicial. And this has been discussed in different settings already. And I have getting missed information, so I cannot tell you what is this about. We need to see it in written. We need to see the agreement to understand it. Now, what is clear is that for those that do not say the truth or do not recognize their liability, those will go to a tribunal, and those will have an adversarial criminal trial. That is clear. So for those who do not make a confession, they go to the tribunal of the Special Jurisdiction for Peace. And this is an adversarial criminal trial. But for the first one, which will be the vast majority, we don't know yet. And yes, that has an impact concerning, for example, in my view, that has an impact concerning the preliminary examination of the International Criminal Court, among other things. It's not the same to bring the matter to an administrative body or to a body comprised of members agreed upon by the party that to bring the matter to judicial body. Now, again, and now we are going to just go into the end of the presentation. Let's talk about penalties, because this is a topic. In fact, I came to The Hague and suddenly I realized that in the Netherlands there is at least 10 persons doing a PhD about punishment in international criminal law. We are trying to make a quadrangle or a rectangle out of a round. So basically, we are trying to see what is the nature of punishment, whether we can have something different from imprisonment when we are talking about the most serious crimes of international concern. So, we may commit genocide or crimes against humanity, but maybe if we do some community work, 80 hours per week, oh, not 80 because that's slavery, let's say 50 hours per week to be more considerate, maybe that's enough. So, as I say always to my students, if I do 50 hours per week of community work during the next 10 years, how am I going to explain that if somebody steals my mobile phone, which is the shittiest one on earth, this one, it's well known in Bogota, so you get 8 years of imprisonment, or 6 years of imprisonment. How do you explain that? How do you explain the role of imprisonment as a penalty at the national level if those that commit the gravest crimes, they just get community work? Maybe we should start all looking at indigenous jurisdiction, because some indigenous jurisdiction, they deal very well with these issues. So if somebody assassinates the head of a family, or a member of another family, they don't go to jail. They have to provide the material means for the survival of that family for the rest of their lives. So you don't go to jail, you just work for the family that you have harmed by your action. So maybe we are starting moving towards a new direction in national and international criminal law as such. But as long as this is not done, I cannot explain my students, and I cannot explain my neighbors, and I cannot explain anybody how you commit crimes against humanity, you do community work, and if you steal a cell phone, you go to jail for a few years. Now, the functions, again, interesting. Can anybody tell me, anybody who has studied criminal law, if it's possible that one of the functions of criminal law is to satisfy victims' rights? Is that the goal? Is that the main goal? Because here is the main goal again. And this, you can bring it back to the main goal of the Special Jurisdiction for Peace, satisfy victims' rights. Has anybody studied that victims' rights are the main goal of sanctions and penalties in criminal law? A ver, Carlos, who is an expert from Bogota, he's a great expert. No? You have studied this matter for several months and years. With me. And with others, professor of criminal law in El Rosario. Has anybody told you ever that victims' rights has anything to do with penalties in criminal law? No. And here is the main goal. Amazing. Now, the second goal of penalties is to consolidate peace. Again, Carlos. Has ever been consolidating peace a goal that any professor of criminal law ever took into consideration when they were drafting their manuals on the basic part of criminal law or the special part? Never. Never. So maybe, as I said, maybe we are not talking about criminal justice. Maybe we are talking about something else. We have to wait and see. Now, and this is the function of the penalties. Look at the function. The functions are even more amazing. Because the functions are about restorative justice. And repairing the damage suffered. These are the functions of the penalties. I thought that we have a distinction between truth, justice, and reparations. And reparations was something different from justice in terms of having a procedure, a process, and then having a conviction or acquittal, and then serving a sentence. So yes, leave it for the reparation side to repair victims, but don't try just to have as the main goal of your sentence is reparation. So we are not talking about retribution, we are not talking about prevention, special repression, general prevention, we are not talking about resocialization, we are not talking about any purpose whatsoever of criminal law. It's like it doesn't exist. They are not relevant. This is fully different. Are we sure about that? Are we sure that the penalties in international criminal law have nothing to do with national criminal law? Have we read the jurisprudence of the ICTY? Because they have discussed it at length. And it looks that they are pretty much related. Well, it doesn't look that way here. Now let's look at the component. And this is where it comes, this is the key question. I promise a few more minutes and I'm done. Now, those that say the truth and acknowledge liability, they are going to get this. They are going to get a penalty, and let's read it together, that will have a component of restriction of freedoms and rights, which will aim at ensuring victims' restoration and reparation by performing different types of works and activities. So, for those who make a confession, for those who say the truth and recognize liability, it doesn't look it's going to be deprivation of liberty, it doesn't look it's going to be imprisonment at all, and it doesn't look it's going to be even restriction of liberty. It's restriction of freedoms and rights that is going to be performed by community work. That's what I'm saying. That's the first category. Now, the second one qualifies the first one because it says only in cases of serious crimes. And then when I was reading this, I said, well, and which one of these is not a serious crime? We have genocide, we have crimes against humanity, and we have serious war crimes. Not just war crimes, serious war crimes within the jurisdiction of the special court. So if we have only those three categories of crimes, which one is not going to be serious? Because, so I thought, well, maybe the first option is just a hypothesis that will never be applied. Maybe, or maybe not. We have to wait and see. Now, the second option is different, because the second option talks about serious crimes, and if you understand that every crime that will be confessed there will be serious, everybody will get, at the very least, restriction of liberty for 5 to 8 years, something similar to what they were getting in the peace and justice law. But here it is the key. They are not talking about deprivation of liberty. Here it is said restriction of liberty. And what is the difference between restriction and deprivation of liberty? then is when the whole discussion opens up. Because some are saying that restriction of liberty means that basically you cannot move within the whole country, so you will be confined to one of the departments in Colombia, and then you can move in that department, or at least in certain municipalities, and have a normal life, and you do normal business, and you do political life. And the restriction of liberty will mean you will not be able to exit, to leave that area. If that means that, I have many hesitations to say whether that meets the ICC requirements at all. But we don't know yet if it means that, because there is a whole discussion on what it means restriction of liberty as opposed to deprivation of liberty. And remember, the restriction of liberty is the highest penalty for everybody who says the truth and acknowledge liability. Now, for those who decide to acknowledge liability late, so just wait and see, you think you're going to get away with that, and suddenly you remember, your lawyer comes to you and makes you remember that there is another option, that before facing an adversarial criminal trial you may make a confession, say the truth, acknowledge liability, it's late, you are not going to get restriction of liberty, you are going to get imprisonment, but just for 5 to 8 years. So that is imprisonment in ordinary conditions for those who acknowledge late their responsibility. We don't know what does it mean to acknowledge it late. We still have to see which are the criteria. But obviously this is very different from the previous case, in which we have restriction of liberty. Now, the last one is when we move to an adversarial criminal trial, and then yes, in the adversarial criminal trial you get convicted, you may get a penalty up to 20 years. And that is in prison. That is very clear. So it's not a full-length penalty. It will not be the 40 years that you will get in normal conditions, but you can get up to 20 years of imprisonment, even if you don't recognize your liability. So they cut to half the penalty that you will normally get, even if you refuse to cooperate, and even if you refuse to acknowledge anything and you go to a trial. Here you have the conditions. In order to get an alternative penalty, so in order to get to the 5 to 8 years, if you have a late acknowledgement, or the 20 years in case you have a conviction. You need to contribute to social rehabilitation. You have to make a commitment that you will be working, training, or studying, and then you get the alternative penalties. Now, here it says alternative penalties in those cases of deprivation of liberty. So we don't know if this commitment has to be made by those in the first category, by those who say the truth and acknowledge their liability. Because in those cases we either have restriction of rights and freedoms, or we have restriction of liberty, not deprivation of liberty. It's unclear as well. That's the reason there are many questions that has to still be sorted out, that we cannot make an assessment because we don't have the text with us. Finally, and with this we will end the presentation, the final clauses of the agreement. The final clauses of the agreement, the first one is very important. The first one says, to access any special treatment, so basically, to be subjected to the special jurisdiction for peace, you need to provide full truth, compensate the victims, and provide guarantees of non-repetition. Now, any judge, any member of a commission who takes this seriously can make this work. So if you really say you don't get the benefit unless you provide the full truth, unless you compensate victims, and unless you provide guarantees of non-repetition, and you take it seriously, and you really condition any benefit to full compliance with this requirement, you can make something important out of this. You can make this an effective, or at least to a certain extent an effective tool for a transitional process. But again, we don't have the criteria. And again, we do not know how this will be applied by the judges or by the members of the chambers. So this is clause number 8, the most important one, probably, of the whole statement. It's at the end, but it can give room for many things, depending on who is in the chamber. Now, clause number 9. This will only work in relation to the FARC if the FARC starts surrendering their weapons, of course. This is a final agreement in a peace process. So after the peace process, you have to surrender the weapons. Now the question here is, and we don't know yet, what does it mean surrender? It means that we are going to give it to the Colombian army, or that we are going to give it to a third party, or are we going to keep it and say that we have stopped using the weapons? I don't think that this last option will fly at all. But what does it mean exactly to surrender, and to whom? This is also something that we don't know and that is being discussed right now. And finally, everybody shares the goal that the FARC will become a political party. And the Colombian government will support, in the terms that will be agreed in the coming months, for the necessary step to be taken for the FARC to become a political party. And that is the last clause of the agreement. Now, as I said at the beginning, we don't have the text yet. We are working on the basis of a public announcement, of a press release. As we can see, there is notable differences, or important differences, in relation to the legal framework for peace. It looks like that we have judicial involvement in here, and it's not going to be just extrajudicial. But if we look at the details, we still need more information to see exactly how these chambers will be, who will be part of them, how they will operate. We also see certain problems concerning the goals of the penalties, and even the goals of the whole jurisdiction. It might be that they have design goals that are unachievable for a jurisdiction, that are unachievable for a penalty. It's like for me, imagine that my goal for next year is to have long hair. For the penalty, it's the same. Imagine that the goal for the penalties is to satisfy victims' rights and to consolidate peace as the main goal, even as the only goal. Okay? So, we also have unclearness about the exact content. What does it mean restriction of rights and freedoms? What does it mean restriction of liberty? What does it mean deprivation of liberty? We also don't know whether the prosecution office, hopefully so, of Colombia will be involved, or whether this will not go to the prosecution office and will go to an administrative body agreed upon by the parties. So there are many things that we don't know. What we really see is that this is different from the legal framework for peace, that this is to some extent coming back to the peace and justice model, but we don't know yet how much is coming back. Probably will be something in the middle. And that still there's many shadows, and also we can see a number of lights in this special jurisdiction for peace. And in particular, we have also seen that for the first part, in all transitional mechanisms that have been put in place in Colombia, this comprehensive agreement is dealing with social, economic, and political matters. And we have to continue also that path, because either the measures in this regard are taken, or whatever we do here, on truth, on justice, on reparations, and on guarantees of no repetitions, will not suffice. Will not suffice. Will not get people out of poverty, will not get people out of disenfranchisement. And if violence is a good business in the country, I'm afraid it will continue being a good business in the country. Thank you very much.
Thank you very much, Professor, for this very interesting talk, which indeed I think shed quite some light, but also thank you for pointing out all those shadows. We now have some time for Q&A, and I assume, since you already dropped yourself a few questions, that we can foresee an interesting discussion. I have a colleague who will pass on the mic, but maybe, oh, you have one. Please state your name and affiliation when asking question. Can I start there and those two? Yeah. Oh. Do you like to take some rounds?
Thank you very much.
One by one round. Yeah.
My name is Juan Quintana. I'm the ambassador of Colombia here in The Hague. Thank you very much, Héctor, for a very comprehensive presentation. I know from the outset you told us that you were going to provide us with questions more than answers. And of course the root of that is that we still don't know the full text of the agreement. All your presentation has been based on the press release number 60. Perhaps when we have the text, some of those questions will get answers. For the time being, and on the basis of the press release exclusively, I would like to know your personal opinion on the chances that this model have to succeed. In order for it to succeed, it has to be accepted by the Colombian people, of course, but it will also have to pass the test of compatibility with the Rome Statute, an assessment that will be made by the ICC, essentially. So, do you think that on the basis of what we know now, will this model succeed? Does it have a chance to succeed? Thank you very much.
Thank you, Héctor, for the presentation. My name is Daniela Kravitz, and I work in Colombia with UN Women. I have a question for you regarding the potential amnesty law that you referred to that will be adopted if the peace agreement is signed. You mentioned that the amnesty law is meant to cover political and connected crimes, and I just wanted to know your views of what is understood by connected crimes in the context of that amnesty law, and what sort of discussions are taking place in Colombia regarding this. And I ask because I know that the FARC in Havana are pushing for a very, I would call it, creative interpretation of what can be considered connected crimes. Thank you.
Yeah, thank you, Hector. Dan Saxon from Leiden University. It's a related question to Daniela's question. One step back, you mentioned that people may receive amnesty for political crimes. Is there any indication what the definition of a political crime will be?
Thank you for your presentation. I'm Patricia from Leiden University. I wanted to know if the FARC, being a legal political party, how is it seen in the population? How is it taken? And second question that is related, is there any limit to their maybe candidacy and what they are able or allowed to kind of put in the agenda? Thank you.
Thank you. Well, answer this question and then take second round.
Okay, let's start with this last one. I think that the population, for the most part, is not in favor of FARC participating in politics. Most of the population is against. It's against, and you can see why. They have been told that they are terrorists for the last 40 years, before they were guerrilla members. So basically they were the enemy. And suddenly the enemy participates in politics, and they might also have seats automatically in Congress. And that is difficult to understand for the majority of the population. So I don't think that they are in favor of that. Now, this means also that one of the main challenges of the process will be security. We have a tradition, or at least we have not a tradition, but a dynamics, in which those that have been demobilized, to a certain extent, have been victimized. And it's not just the Patriotic Union in the 80s and 90s, it's also the paramilitary members that were demobilized. In 2006, we have more than 3,000 that have been killed. So there is an important issue concerning security. And the issue is more important even taking into account that some of those members of paramilitary groups became members of Bahrain, that others are living out this year. They are leaving prison this year because the 8 years of the peace and justice law is just over right now. So you have some still mobilized, others that are coming out of prison. So it's a real challenge how to ensure security. Concerning the political crimes, I think that they will apply the national law on rebellion. So that's basically what I believe that both of them are looking at. Colombia has a quite developed legislation on political crimes, and I think that they don't have to look at it. I don't think that they are not looking elsewhere, but just to apply what they have in the criminal code in Colombia. Amnesty laws, related crimes, and there is when the issue that trafficking comes in. That is obvious that it comes in. Drug trafficking has been a major source of income for every organized armed group that have operated in Colombia. This is a reality. This is a fact. So what I suppose is like the claim that it will be made is like if that was a key source of financing of our group, that is connected to the conflict. And I suppose that by saying so, they will try to have drug trafficking covered by the amnesty law. But I don't think that this is really, for Colombians and in Colombia, the key question. Because if you really are honest and look at the reality there, you see that all groups that have been involved, as far as I know, they have gone into drug trafficking to keep their financing up. Maybe there was one example in which there is a commander in Medellin, I don't know if from Bloque Metro, he was exterminated in 2002. They tell that Rodrigo Doblecero did not want to get into politics, into drug trafficking, and that he was exterminated by Cacique Nutibara and by Bloque Central Bolívar as a result of that. I cannot tell you 100% sure if that was the case or not. This is what I have read. But most of the armed actors, I would say all, have profited from drug trafficking. So in that situation, would you include drug trafficking as a related crime to the armed conflict? And if you leave it out, what does it mean for the process? Everybody is involved. To put it in simple terms. Now, chances to succeed. That depends on how the model will turn out at the end. There are lights. There are lights. This is, I believe, is a better agreement. It's a better mechanism than the legal framework for peace. Much better. And I have said that consistently since the legal framework for peace was put in motion in 2012. Now, we still need to know, as we said, what is this special jurisdiction for peace about? Whether it's part of the judicial body, whether it's not part, whether it's composed of judges, or whether it's composed by academics, which are the ones that are members of the latest Truth Commission or Commission for the History of the Conflict and the Victims. We also need to know what are the penalties about. I don't think that community work will suffice. I don't think so. I have said that clearly many times, and I will say it again. You cannot justify community work for crimes against humanity and genocide and serious war crimes as they have here. And if you do so, criminal law loses all function within the state. So we have to see. It will also depend, and that is for me one issue that I see already, that Colombia is not getting enough support of the international community. And I have to say that clearly. Nobody wants to put any money for reparations. Nobody wants to give a penny for reparations of Colombians. Nobody wants to accept in their own territory any of those who may be demobilized. So you want to stop violence in Colombia, but you want to have them all in Colombia. So when you look to practical matters, not just to put in pressure on Colombian authorities or working with Colombian authorities, however you call it, but when you look at practical matters, like providing resources, like making yourself available to have some of the demobilized people, nobody is cooperating with Colombia. That's not going to help. Also, I believe that this will also depend on the economic and social conditions in Colombia. Labor is key here. People need to have decent labor conditions to get out of violence, because otherwise violence is a very interesting alternative. If you don't have many options, and you have been born with violence, and you have grown with violence, and you have worked in violence, and they don't offer you other options, what are you going to do? And also victims must be given proper conditions to get out of misery and poverty. Because otherwise they will look at, watch out, those that were involved in violence, they are provided with opportunities, and we are not. And that means that you need to have changes in the economic model, economic measures. Are they willing to do so? We have to wait and see. Otherwise, we'll be back here in a few years' time saying this might not have been successful, or that might not have been as successful as it could have been, but you need to have structural changes. You do need that, and you need to create employment. And more so, and let's just give another step, and then I will stop here, foreign countries need to help on that.
Should we take more questions? It's in the... yeah, right.
Thank you. Thank you for the lecture and the opportunity to make comments on this subject, which is I feel very close to our own experience, because I'm from Latin America, I'm Chilean. And I would like to make a general comment on the question of relationships between peace, justice, and the model you take and the model you follow to achieve some general goals. It's very easy from the chair or from the academia to see some models that are applied here and there, but then when you go to the real negotiating table, you will find actors that are not able to deliver what you want them to deliver. So you have to, at a certain moment, to make accommodations or to bring people to a certain accept certain frameworks. That is something that is not only here in the case of Colombia, everywhere. So the role of law is very difficult, because you need to enforce law, but at the same time you have to create norms, and in order to make values to be accepted by everybody, you have also to reinforce and strengthen the role of law in that society. And the case of Colombia is not alien to some other cases in Latin America. in which you have had to establish a new set of rules according to international law, of course, but new set of rules that are applicable to certain societies. And having said so, the question of the relationship with the International Criminal Court, in case this scenario is completely over, so there is no agreement, no justice, no new system being applied in Colombia, which would be the role for the ICC in terms of peace or in terms of rebuilding a society and putting end to the violence? Do you think that the ICC could work alone in a situation like that, or it will also need the domestic setting, it will also need some agreements within the society and international political support of some foreign actors, stakeholders? Thank you.
Thank you very much for your excellent presentation. My name is Yad Masoud. I'm a PhD candidate at the University of Paris-Est. I have a question concerning the. You have mentioned that direct and indirect actors may be tried before this special court. So I have a question concerning the mode of liability. This court is competent for international core crimes, and in context with its relationship with the ICC, will it apply the mode of liability as it is conceived by international criminal law or by the Colombian penal code, or what is the mode of liability that will be applied for those crimes? Thank you.
Thank you, Héctor, for a very interesting and engaging presentation. For those who don't know me, my name is Mariana Pena and I work for the Open Society Foundations. I have a question about the possibility that the system also applies to the army for crimes committed by the army. I noted that in some of the slides you explained that there was a reference to all actors. So the question is, what is the likelihood in practice? How does it relate to the reform of military justice? And how is it affecting negotiations? Thank you.
Hello, my name is Hanif. I'm Hazara and Afghan people, but for the genocide, because we Hazara people for many years is genocide people. What kind of genocide you have it in Colombia? And the second thing, I need some advice which way in Afghanistan going to make peace, because as you said, nobody spend money for Colombia, but in Afghanistan for 14 years they are spent a lot of money, but we don't have any peace and it's going very worse. If you can give me some advice. Thank you.
Sí.
Will Worcester University. I'm interested in what your view is on whether or not this this whole model is just a sort of masquerade as a judicial process, because I'm very impressed to hear about how you keep saying everybody's into it. I mean, all the senators are involved, everybody's involved in this, and so if you have a proper judicial process with a proper criminal process with proper sentencing, a massive amount of the population is going to be in prison for a long amount of time. Where's the money going to come from? It just seems like, and I've also been very impressed to hear about how you need to have a larger political process with land reform and addressing the drugs and everything. So you need to have a political solution. So you have a political solution, but it's sort of dressed up as a judicial process, but in fact it's not really a judicial process. And then I wonder, who are they dressing up for? Are they dressing up for us in The Hague? So we look over there and we say, we know judicial process, and we see you doing something that looks like judicial, so we're impressed. Or are they doing it for themselves? Thank you.
One more? Okay.
Hi, hello, good evening, everyone. My name is Miguel Ángel González Ocampo, and I work for the Embassy of Colombia. I used to be more confident, to be honest, but now I am a little bit nervous. I feel the pressure because my boss is on my right, and the deputy of the embassy is behind me. So please be indulgent with me. Well, to begin with, Héctor, it's very positive that you refer to shadows, not to darkness. So it is very good. You made a fundamental distinction at the very beginning of your presentation when you say that for you what is going on in my country is a transition but not transitional justice. If I'm correct, please correct me if I'm not. Perhaps what is below this assertion is the fact that the law in one way or another is something different to politics. And I think that here it is a matter of debate. Because if you consider the law as a political outcome at the end, lawmakers are politicians in most of countries, we must realize that the fact that the agreement that hopefully will reach, I mean the final agreement in Havana, even though it will be the outcome of a political negotiation, it doesn't mean that because of that it is not law. In this vein, I'd like to put forward that there is also a fundamental distinction we must bear in mind, and that is that there is law that applies for a peaceful situation, and there is also law that applies for a war situation. And the key thing here, and let me insist on this because this is very important, the key thing here is that we are talking about a country which is facing a non-international armed conflict, or to use a non-legal term but a more vulgar one in the good sense, is at war. That's the thing. That's my first comment. It's also key to consider that we're talking in a great extent based simply on a press release. Even though the Colombian media, and I'm quite outspoken about it, if I'm saying something wrong, please kick me. I'm quite outspoken because even the Colombian media, El Espectador, El Tiempo, Semana, and so on, have published pieces of the 75-point agreement that everyone is expecting, is waiting for. I think that it is not precise to suggest that the Justice and Peace Law, the 1975 of 2005 law, is the result of a combined action of the Inter-American System of Human Rights and the International Criminal Court. I will say that yes, both of them play a role on the one hand, but on the other hand you must consider that Colombia has dealt with violence, as you clearly pointed out, not during the last 10 years, not 20 years, but roughly during the last 50 years. So it's also important to consider the national element. Otherwise, we create, in implicit terms, a vertical relationship in which the so-called international communities evolve and national authorities are simply receiving input and reacting to those inputs. It's also very relevant to consider Article 6.5, Héctor, because you clearly said that article invites in some way, because the language both in English and Spanish is not mandatory but rather exhortatory. Shall endeavor in English. In Spanish is procurarán. Authorities empowered to grant the largest amnesty possible. The tricky thing here is, okay, what does the largest one mean? You say that from the very beginning the International Committee of the Red Cross said that it was not going to apply to crimes against humanity, war crimes and genocide. It is not correct. If you look at the first commentary of 1977 of the ICRC, the ICRC itself has indicated back then that the goal was to reach the reconciliation. Reconciliation, it was the word used by the ICRC. What happened? In 2004, the International Committee of the Red Cross issued a study in which I think it's Rule 139 of customary humanitarian law, in which it says that it cannot be granted in cases of war crimes. Indeed, it doesn't talk about genocide nor crimes against humanity, probably because the task of the ICRC is international humanitarian law. Probably that's its explanation. But the point is that the study of the International Committee of the Red Cross is not a source of law. It is not. You may be thinking right now about the Inter-American case law, the ICTY case law, the ICTR case law, European case law, and so on. And you know that this is a matter of debate, of course, whether there was or not a change, a fundamental move in the international case law. You know that the Inter-American Court in the case Masacres El Mozote versus El Salvador, which has been invoked by the European Court of Human Rights, let's say that set up a nuance, a hint in the previous jurisprudence. If you look at that judgment, it is the second time in the history of the Inter-American Court of Human Rights case law that it referred to Article 6.5. And it said that what was most relevant in that particular case is that it was a situation of war. And my boss has just given me a precise instruction I have to follow. I will leave like that. Thank you very much, Victor, and thank you, everyone.
Maria Alejandra Moreno, and I recently graduated from the advanced LLM in Leiden University. Thank you, Héctor, very much for your conference. I think it was very clear. It was very engaging and encouraging, I think, as well. I have a question for you. Do you think that we can foresee maybe a different treatment in the case of FARC members who maybe were victims of recruitment, and then maybe at the beginning they were child soldiers and then they became perpetrators? Do you think that we can expect that in this special jurisdiction? Thank you.
I will try to keep it short, but
yeah.
I have like 8 on a round. And you should invite Miguel Angel for the next conference. An alternative view of Article 6.5. Well, let's start with that one. With Article 6, Clause 5. Last year we have a meeting of the Conduct of Hostilities Group of the International Law Association. And I brought this question to the table. I said, okay, do you think that Article 6, Clause 5 can be applied for international crimes? And there we have, I will say, some of the most important NATO lawyers. And the question was on the table for half a second, or for half a minute. No, it doesn't apply. It's only applicable for non-international crimes. There was no discussion. No discussion. You have German military lawyers, British, Canadians, US military lawyers, Norwegians. So I was surprised there was so little debate. And I was surprised because in Bogota they have discussed this matter for ages. They have made a discussion out of no discussion whatsoever. So that told me what is the understanding, the general understanding of the matter. Now, you refer to the case of the Inter-American Court of Human Rights and that particular case or jurisprudence, but that case, the majority opinion was clear. It doesn't apply. The majority opinion in that particular case said you can grant an amnesty law, but not for genocide, crimes against humanity, and war crimes. It's true that there was a separate opinion, but the separate opinion is not the majority ruling. The majority ruling just kept the same line of jurisprudence they have had for the last 15 years. The same. That in the Inter-American Court of Human Rights. Now, and there is a reason why this is so, and I think that we have to understand the rationale. And the rationale is the following. I don't know if I can spend a couple of minutes on that. International humanitarian law for non-armed conflict is not, let's say, a just law. This is not just. This is not equal for both sides. We have to understand this is law made by a state, and they apply it to the enemy. And that's the reason why the FARC many times say, why are we bound by international humanitarian law? We are not in the negotiation table. We have never agreed to anything. This is being imposed to us, but this has been agreed upon by the states. So why should we comply with that? And this is the question that Article 6.5 is going to answer. Why should you comply with this? Now, it is also important to understand that in non-international armed conflicts, those organized armed groups that are fighting against the state, they are not legitimized to use armed force. They are not. Under no condition they are. Which means that even if they conduct their operations according to international humanitarian law, and they basically direct their operations to state agents, to members of the military, they still are not being legitimized. And therefore the country, as such, has freedom to criminalize that conduct and to treat it as an assassination or a murder, even though it's according to IHL. That's the reason in Colombia you have all members of FARC which are charged with murder, even though it might be the murder of a military or member of the military, and that murder might have taken place in exchange of fire in an operation of the FARC. That is perfectly according to international humanitarian law, and however is a murder under ordinary law. Why? Because international humanitarian law does not prohibit states, does not forbid states from criminalizing behavior that is okay, that is lawful under international humanitarian law. And here is the key. Now then, the FARC comes to us, or the guerrilla members, they come to us and they say, well, whatever that we do, we engage in criminal liability. If we comply with international humanitarian law, we still are criminal according to national law. If we do not comply with international humanitarian law, then we are also responsible for war crimes. And the question is, why should I spend my resources? Why should I put at risk my personnel to keep the rules of international humanitarian law if no matter what I do, I'm liable? And then Article 6.5 says, watch out, there is a reason why. And the reason is that if you follow the rules of international humanitarian law, states have taken the commitment at the end of the conflict that they will try to the largest extent possible to grant an amnesty for ordinary crimes. So if you follow the rules, you may have engaged in criminal liability according to national law, but you will be exempted. You will be amnesty for that criminal liability. Now, if you do not follow the rules, then no matter what happens at the national level, you will not be exempted from your liability for war crimes. So that is the incentive, and the Article 6, Clause 5 gives that incentive. Otherwise, if you make an interpretation according to which you can grant amnesty for all crimes, whether national or international, there is no incentive. The only incentive is to be strong enough so as to be at the negotiation table and tell the state, watch out, now you grant amnesty, otherwise I continue the conflict. There is a whole rationale behind this, and nobody in Colombia has ever discussed about this. Even the Constitutional Court has ruled, and never address this matter. What is surprising to me is like I came to The Hague, or in that case I came to Berlin, and it was a matter that was sorted out in half a minute, because nobody had anything to say. It was clear for everybody. Article 6.5 is an incentive to follow the rules of international humanitarian law. If you extend the scope of this provision to include genocide, crimes against humanity, and in particular war crimes, there is no incentive for the FARC or for any other organization group to spend resources and put at risk their personnel to follow the rules. Very simple. Now, I explained this in my class in El Rosario, but obviously this is a very limited and small context. Okay, let's move to another issue. Concerning child recruitment, I don't know. There is no provision on that in the special in what we know about the agreement, but it's likely. It's likely because this is the direction that things are taking. So it's likely that will be so, but we don't know yet. So I cannot say at this stage more about that. What else do we have in here? Justice and law and policy and politics. This is good it's good that we are getting into philosophy. I love it. You know that I study theology myself. So in the 5th semester of theology, which also have some courses on philosophy, and it's key to understand that justice has nothing to do neither with law and politics. Something different. I always tell my students when I get there as well, do you think if your politicians are good, do you think that your law will be good? Because the law is made by the politicians, as Miguel Ángel was saying. Law is the instrument of politics. And then I said the question the other way around. If your politicians are not good and are corrupted, do you think that law will not be corrupted? Now, does law has anything to do with justice? Sometimes. Law is just. And other times, law has nothing to do with justice. Because when we talk about the justice, we need to look at the theories of justice. And then we can look, if we are talking about utilitarianism, and we are within the realm of Stuart Mill, or Bentham, or we are talking about neo-Kantism or Kantianism, and we are talking about Kant, or we are talking about deserved justice of Aristotle, or we are talking about Rawls. So, in my view, justice does not necessarily can be equal to law, not at all. And that is something that has to be clear since the beginning. Law is not necessarily just. And the example of international humanitarian law is the best example. Because the FARC may conduct all their operations according to international humanitarian law. And despite of that, every single operation can be criminal at the national level. Because the states have so decided. Is that fair? No. It's fully unfair. But this is the law. So now we have Article 6, Clause 5 to try to moderate that situation. Now, let's move to something else. What about do we have in here? To the army. Okay, the army is a key player in Colombia. Key player. In fact, the current president was the former Minister of Defense. So, it is a key player. And why is a key player? It's a key player for several reasons. First, because they are the security forces of a country who has been at war for 50 years. But second, because it's the main employer in Colombia. The army of Colombia is bigger than any other army in South America. It's bigger than the Brazilian army. It's bigger than even the army of Mexico as well. And Colombia is 2.5 times smaller in terms of population than Mexico, and 5 times smaller in terms of population than Brazil, and still have the biggest army. And not only the biggest army, had the best technology in the continent. They employ today around 450,000 people. Not even the church, not even the Catholic Church employs that many people. Not even close. That is the reason they are a core player in this process. And of course the extension, and if you look at the extension of the jurisdiction of the military in the military courts, it tells you all. That failed. That was tried from 2010 until 2014. For 4 years that was tried and it failed. And in the second mandate, the current president again tried, and this time he made it through. Look at how important it is that they have to make sure that when there is armed conflict, international crimes will be of the jurisdiction of military courts. That is not the case for times of peace. But extension means that when there is armed conflict, it will be military courts that will take care of international crimes if there is military involvement. So it is a core player. Okay, yes, we have several more. Now, Will's question is also relevant, and I'm gonna just for a second. I'm gonna come back to my hometown, Spain. Spain is a very interesting country, not always for good, but very interesting one. We have a transitional process in Spain. There was no truth. There was no justice. There was no reparations except for the unions, the trade unions. They got back their property that was stolen, and nobody else. There was no warranty for no repetition. There was no dismissals in the security forces. The judges were the same and continue being the same. In fact, as far as I know, the only judge that has been dismissed has been the one that have tried to investigate what happened there. That was the one who was dismissed. Good example for the international community. However, Spain got out of poverty. People don't realize how was Spain in 1972, 1974, the economic conditions of the country. And it's true that we have had a crisis for 7 years and may get back to that situation, or close to that situation, because we don't have manufacturing and we don't have agriculture and we don't have how to employ. We don't know how to employ the 46 million of Spaniards. So we send them to Colombia, and we send them to Latin America, and some of them we send them to the Netherlands and to Germany, and then after 2 million people has left, then we say still there is 22% unemployment. After 2 million people has left. Now, however, during the transition and the 80s and 90s, Spain got out of poverty. Why? Why? Why West Germany got out of poverty? Pardon, East Germany got out of poverty. Why Poland has gone out of poverty? Why? Because there were resources. Because for whatever reason, Brussels decided that they wanted to have a European Union at that time with 12 members, in which Spain and Portugal will be out of poverty. And they were sending billions of euros for 25 years that created economic conditions to have better working conditions. And Colombia today is at the lowest level according to the International Labour Organization. If you could lift those conditions to the 3rd level as opposed to the 5th, that will be a major improvement. Brussels decided that it wanted to do it with Spain. West Germany decided that it wanted to do it with Germany. Brussels decided that they wanted to do it with Poland. And billions were coming. The leadership was changed, because that was a condition. The leadership was changed, and other conditions were established in order to get those resources. I don't say that resources are just the way and nothing else. I'm just saying that without resources, you don't get it done. Tell me a country that has gotten it done if the international community or major powers in the international community have not committed to put in the resources. And now tell me, who has committed in Colombia? The US has committed in Colombia? The European Union has committed in Colombia? Who is committing in putting those resources in Colombia? Who cares so much about Colombia so as to put the resources? So we need to have resources, change of leadership, conditions, in order for those resources to get into the country. And in addition to that, truth, justice, reparations, and guarantees of no repetition. Now, the ICC. What about the ICC? Okay. There was a mode of liability, and where is the money coming on? You were talking about the money. We have already discussed about the money.
Me?
You talk that Afghanistan is getting a lot of money.
Because you have a lot of things here in
I know. I say money is not enough, but money is needed. But money is needed. It's needed, and I said change of leadership. Maybe I don't know how it works in Afghanistan. Not at the national level, at the regional level is key. It's not just national; it's regional, and it's even local, because this is where many groups operate. Now, let's move now to, as I said, pleasing the ICC. I think the ICC has been for any preliminary examination for around 10 years already. And I think that the ICC has played a role. And we can say that the ICC has played a role, and also the Inter-American Court of Human Rights has also played a role. Because if you look at the proceedings, the judicial proceedings concerning crimes committed by, in particular, state agents and paramilitary groups in Colombia before the intervention of those institutions, were very minimal, were very limited. Now, so they make a contribution. And of course national actors make a contribution. I don't know if you will have a penal chamber of the Supreme Court as the one you had between 2007 and 2010. That was a brave penal chamber. Some of their members were threatened. You also have provisional measures concerning at least one of them by the Inter-American Commission of Human Rights, and they did their job. And there were other actors, not just in the penal chamber, also the magistrates at the peace and justice chambers, and other actors in Colombia. So it's a combination, it's always a combination. Whoever the future of international criminal law, whoever believes the future of ICL is at the national level is wrong. Because almost nothing happens at the national level if there is no international involvement. And whoever believes the future of international criminal law is at the international level is wrong. Because we see how few cases are being tried at the international level, particularly lately. So it's a combination of both. And it will stay a combination of both. And the moment it will stop being a combination of both, you will stop having application of international criminal law. And finally, modes of liability, my favorite topic. I spent more than 1,000 pages on that. And you know what is the funny thing? I finalized that book in a cyber cafe in the outskirts of Bogota. I didn't have even internet in my home, so I used to go every day to a cyber cafe, and I wrote there a treaty on modes of liability. Cyber cafes are great in Bogota. And if they are not in the center, they are in the outskirts, even better. Nobody distracts you. Now, one thing I can tell you, Colombian lawyers are very good. Much better, or at least some of them as good as, or even better than international lawyers. They know everything they have to know about modes of liability. In Colombia, there is enough knowledge right now to apply modes of liability if they have to be applied. It's not a question of knowledge. They know. And they know well. And I will tell you more. Not only they know well, they will be great trainers or some of the lawyers that are around here. So the way in which they will address this issue of indirect participation might be done through theories of co-perpetration, if we are not requesting essential contribution but significant contribution first. Or otherwise, we'll have to rely on theories of participation, particularly aiding and abetting. Now, if you look at the ICC statute, you also have a residual clause of participation, which is assisting a group of people who are acting according to a common purpose. So, of course, there are theories of liability in which not only those that have a direct involvement, that those ones, but also those ones who are far away from the scene of the crime, are also those that did not have an essential contribution, but a significant contribution, or even something which is lesser, might be criminally liable. So, I wouldn't be worried about that. I wouldn't be worried about the theory of liability. They will find the right one, and I wouldn't be worried about the quality of Colombian judges, prosecutors, and lawyers, because they are excellent. Remember, there's only 3 countries in which they have applied international criminal law consistently, and you are talking about the lawyers of one of the countries who has applied, and we bring it every year. Judges and prosecutors from that country, and they show every year what they have done, and it's good stuff. Thank you very much.
Thank you. Before concluding the session, I would like to make just a small announcement. We have another supranational criminal law lecture next week on the 16th December, where Sean Murphy from the ILC, it is the ILC Special Rapporteur on Crimes Against Humanity, and he will come give a lecture entitled Inside the ILC Towards a Convention on Crimes Against Humanity. And if you want to keep updated, I invite you to subscribe to our newsletters, which you can do either via the website, or also there are some forms at the back of the room. With that said, I wish to thank you all for coming, and to thank Professor Olasolo for this very interesting lecture once again, and hopefully see you soon at other events. Thank you.